Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. My name is Pam Esquire, also known as The Law Intellect. Welcome, everyone, over to this channel. Make sure you hit that like button on your way in. Consider subscribing to the platform if you have not done so already. If you are new here, I want to make sure that I personally welcome you to the platform, and I appreciate you choosing to come over here and analyze with us. If you don't know, we identify as the social media jurors. That means we get cases from the neighborhood to Hollywood, and we go over the cases and we look at the pleadings, and we always try to look at both sides. Well, if you are new here, you probably are unaware. If you haven't come scrolled through all my videos, one of the first criminal cases that I covered was the Tory Lanez Meg the Stallion case. And in fact, myself and my family went to California. We were there for 2 long weeks because I still don't understand why that trial took so long, in order to give you blow by blow, play by play. Now, the thing about this case is I knew of Meg the Stallion and maybe a song before I came into the case. I didn't know who Tory Lanez was. So my opinion was definitely unbiased, despite what some people say. I sat in that courtroom, and there were so many theories that were going back and forth, back and forth. Just all these different theories. But there seemed not to be any evidence to a lot of these theories. For those of you that are unfamiliar with the case, Tory Lanez was tried. He's a rapper. Government name Daystar Peterson. He's from a Canadian rapper, but he's lived in the United States for some years. And he was convicted of pulling the trigger and injuring Meg the Stallion. And as you guys see, she's out. She had a video, came out a couple of weeks ago, a new song. Today she's been trending as far as, I guess she's independent now and she has a distribution deal. Well, interestingly enough, on today, we all know that Tory Lanez has been trying to get out. His team of attorneys has been trying to get him out. He's been through a number of attorneys, and they've tried to get him out on bond pending his appeal because they felt like his case was unfair. Now, just to refresh some of your recollection, or even those that don't know me and didn't know my coverage, again, I didn't know any of these people. The thing about this case is you're going to have those that are just all pro Meg the Stallion, and you have those that no matter what happens, they're going to be all Tory Lanez. The problem with the Tory Lanez portion, and again, y'all got to monitor this chat because you already know how it goes with Tory Lanez, folks. I love y'all, but sometimes you're tripping. But the problem with that is a lot of the things that they were saying was speculation, and I was trying to relay that fact when I would cover this case. So, for example, there was a theory that Tory Lanez did not actually pull the trigger when it came to shooting Meg the Stallion, even though she testified that it was Tory Lanez who shot her. She said that on the stand. I heard her with my own ears. There were individuals that said it was her best friend, Kelsey. People to this day, as we sit here, are under my old videos arguing with me about Kelsey did it, Kelsey did it, Kelsey did it. There was gunpowder GSR that was found on Kelsey's hand, and I believe it was also on Tory's hand. There was none that was on the security guard that was there, or bodyguard, whatever he wants to be referred as. The issue was when you go to court, what we say as attorneys is not evidence. What does that mean, Pam? I'm so glad you asked, and you're so attentive in this chat. What I mean is that I can get up and open an arguments and I can say, ladies and gentlemen of the jury, you're going to see that there's an issue with Roc Nation, that they were just upset because Tory did not want to sign with Roc Nation. You're going to also see Kelsey Harris is going to testify. GSR was on her hand, but she was really the one that pulled the trigger. You're going to see that someone just giving a bunch of speculation. So as I sat in the courtroom, I just knew at least somebody from Roc Nation, somebody from anywhere is going to testify to all this stuff that the attorney was saying. Because again, what we say is not evidence. And in fact, when a prosecutor starts out their opening statement, we take very, very diligent notes because we hold you to everything that you say the evidence will show. And if you don't come through, then I'll tell the ladies and gentlemen of the jury, listen, the prosecutor said the evidence is going to show A, B, C, D, and E. And as you see, they have not held up their end of the bargain because it's their proof. It's their burden of proof. It's not the defendant's. But in this case, there were a lot of insinuations on cross-examination that allegedly Kelsey is the one that did this shooting. There were a lot of insinuations on cross-examination that all of this precipitated because Tory did not want to sign with Roc Nation. Again, my issue with the case, all of that could have been true. My issue with this case is not what you say, it's what the evidence will prove. Now, regardless of whether people like Meg Thee Stallion, she testified as a witness, obviously, for the state. Her testimony is witness evidence. It is evidence. People say it's he said, she said. No, she directly testified as to who she said shot her. So since that time, again, Tory got sentenced to some astronomical amount of years, over 10 years. And so there was an organization at his sentencing called, I believe they're called Unite the People. Unite the People. One thing I did learn at the sentencing was that Tory Lanez he had a lot of philanthropy. He's donated a lot of money. Now, if you guys watch the case, he's had all these whole high profile people that, in my opinion, were just a waste of money. I said that before. I also told you guys, dealing on some of the things that they were saying, they needed to find new evidence or find evidence for what they were saying. And then that would be more beneficial to any motions for a new trial, habeas corpus, or other appellate type post-conviction motions. So what we have here is today, there was a petition for habeas corpus relief that was filed in the appellate court. Shout out to Milagro. She is actually one of the people that is a advocate for Tory Lanez. I'm sure many of you probably know who she is. She actually did send me the court document. I saw some of the posts of the affidavit that people were kind of reposting, but you know me, I want to see the whole document. So I was able to see the pleading to see what they are alleging. Now, one of the issues that occurred was on the night in question, and I said that before, there was a security guard. Oh my goodness. Sorry, guys. There was a security guard who was driving the vehicle where all of this started. And we're going to read over the document for those that don't know the facts so you won't be lost. The security guard, and let me try to refresh my own recollection on what happened with the security guard. I just know he never showed up. His name is Jaquan Smith. He never showed up for the trial. And then I believe it was when deliberations started, he showed up, and we were all like, "Is that Jaquan?" Everybody was going around like, "Wow." There was another person, Juan, who was Meg the Stallion's bodyguard. He showed up at the last minute. Everybody was just showing up at the last minute. But needless to say, none of them testified. Let me look up what happened with Jaquan. Again, Jaquan is Tory Lanez bodyguard. Jaquan Smith. Let me see. Um, hold on, guys. Jaquan. Y'all talk amongst yourself. Hey, really, B? Hey. Um, God, these articles are so one way or the other. It's like, anyway. I'm going to pull up the motion and we'll go over the facts. So I was trying to see what the articles were, but they're so one-sided either way, so I'm not even going to rely on that. I am going to show you the actual document that was filed today. You said you can't hear anything. I wasn't saying anything, so no. You said Empress Fee said he showed up to testify, but the DA asked for 2 weeks to prepare for court. Yeah. I understand that he showed up. I know when he showed up, but it was literally he showed up, but it was not during the case in chief. He showed up like the jury was already deliberating or something like that. Like it ended up being this big old, everybody was in the hallway, they were in there talking and all of that. Let me make sure. Because I know the other Juan showed up as well. So I want to make sure I'm not mixing those two, or Jawan, I think it was his name. Uh hold on, guys. Hold on. Let me see. Oh, love you said your volume was down. That's okay. Oh my goodness. Yeah, I'm not crazy. So this is the article. Meg, okay. So let me see. So Justin, that's his name. That was Meg's bodyguard. He was missing. I remember when he showed up, he had like a warrant. Now I gotta find key witness. This they keep talking about Justin. I don't know why I was calling him whatever I was calling him. I'm trying to find Tory Lanez bodyguard. Jaquan. Okay, I'm just yeah. Okay, let me do what I was gonna do in the first place because these articles is not gonna do it for me. Hey, Andrew. Yeah, Justin showed up after trial. Okay, Empress Fee, you own it. You own it. Justin showed up after trial, but clearly neither one of them showed up on time. That I remember. Neither one of them showed up on time. But Christy, I need you to have an open mind, okay? Let's read the document before we come to the before we come to a conclusion, Christy. Okay, it's 400 of you guys in here. Make sure you hit the like button. So this is a document again. This was from Milagro, who had this document and she gave it over to your girl. Shout out to her. As you guys see, it's like 60 pages. I'm not about to read all that. But this is a petition. Let me go to the beginning for a writ of habeas corpus. Okay, so you guys know what the name is. And it was filed today on the 12th. Okay. The statement of facts, statement of the case. Petitioner Peterson is an individual incarcerated at California Correctional Institution State Prison in Kern County, California, and remains confined under the custody of Warden Brian Cates. Interested parties to this petition may include Ronald Bloomfield, Director, California Department of Corrections, and the people of the state of California, by their attorney, George Gaskin, Los Angeles County DA, and the California Attorney General, Rob Bonta. Why are all these people named? When you do a habeas petition, you're saying they are illegally detaining you in the facility. So because of that, you sue the warden, you sue the directors. There are so many people that you sue in a petition for habeas. And actually, a petition of habeas is considered more of a civil litigation. It's not a criminal. So even though that Tory has filed an appeal on his criminal case, this is being filed along with his criminal case. So petitioner is the defendant in the Superior Court of the state of California, County of Los Angeles, and it has the case numbers. Petitioner respectfully requests that the court take judicial notice of the transcripts, files, briefs, motions, and records in this case. On December 23rd, 2022, so almost a year ago, petitioner was convicted by a jury on count 1, assault with a semi-automatic GUN, personal use of a GUN in violation of Penal Code Section 245 sub B, finding the assault had been committed through use of a GUN causing great bodily injury through Penal Code Sections 12022.5 subs A and D and A2. Count 2, having a concealed firearm within a vehicle, not registered in violation of Penal Code Section 25400 subs A1, and count 3, discharging a GUN with gross negligence in violation of the Penal Code, and those are the sections. So for those unfamiliar, those are the actual charges that he was convicted of. Petitioner was sentenced on August 8th to the midterm of 6 years for count 1, with the attached enhancement carrying an additional 4 years. So it was 10 years that he was sentenced to. The second enhancement was dismissed to counts 1 and 3. With count 2, the midterm 2 years was pronounced to run concurrently to count 1, while count 3, the midterm of 2 years, was stayed. Petitioner received a total of a 10-year sentence. So let's get to the statement of facts, okay? This is, and they take directly from the transcripts, even though I'm sure they don't necessarily agree with it, as they will say in the first paragraph. The following facts are derived from petitioner's Superior Court case, yet he still maintains his innocence. More detailed facts as developed in said trial are contained in the petitioner's opening brief and are incorporated herein as if set forth fully verbatim. Basically, they have an opening brief that has a lot more information, and they're saying we're just going to incorporate that so you can kind of, refer to that document as well. In the early hours of July 12th of 2020, petitioner, his driver and bodyguard, Mr. Jaquan Smith, hereinafter we'll just call him Smith, Miss Pete, that's Meg the Stallion, we'll just call her Pete, and Miss Harris, that's Kelsey, we'll just call her Harris, were traveling in a vehicle from a pool party where they had consumed numerous alcoholic drinks. A verbal altercation ensued and the vehicle pulled over. This situation culminated in a firearm being discharged in the direction of the ground. Pete sustained injuries to her feet. However, she first claimed that these injuries had been caused by broken glass and not from ricocheting bullet fragments, as was later charged. Pete testified that it was the petitioner who caused her injuries, yet she gave conflicting statements as shown above. Yeah. Pete stated that the variances were because she was embarrassed, traumatized, and scared of the police due to the recent George Floyd incident. She did say that. So those in the parentheses, for those that don't know, is where they're getting the facts from, which are derived from the actual trial transcript. Harris invoked her right to not self-incriminate at the trial, to which the people offered her immunity in exchange for her testimony. Kelsey Harris got on that stand, and it was the most irritating, annoying circus of a scene of testimony that I probably have ever seen. She got on the stand, didn't remember nothing, not even her name almost. Okay, I'm exaggerating, but that's pretty much what it felt like. Everything was, I don't know, I don't remember, I don't recall, I don't know what happened, whatever. Despite such, Harris still testified that she could not remember to most of the questions posed. This allowed the people to move for admittance of prior statements made by Harris in an interview by the prosecution. The 80-minute statement was played in its entirety to the jury without the defense ever receiving a transcription of such prior to the trial. That is actually not true on how that happened. What had happened was, when Magdesian, who was the trial attorney for Tory Lanez, was cross-examining, he was actually doing a pretty decent job with Harris for her being, she wasn't on any side. It wasn't like she was doing it to try to favor Tory. She wasn't trying to help nobody, basically, when she was on the stand. So what he ended up doing was he opened up the door because he went too far. I gave him props at first. I said, oh, okay, he's cross-examining. You know, he's doing a decent job. But then he just went too far, in my opinion. And I seen where it was going. So what he did was he had got Kelsey to almost, well, I'm not going to say almost. She said she was afraid. And that's why she said the stuff she said to the police, where she was blaming Tory and all of that. That's what Kelsey basically said Tory did it when she talked to the police. And she was backpedaling, saying she lied and she didn't know who shot Meg and all of that when she was on the stand. So when Magdesian was cross-examining her, for those that weren't there, haven't followed the case, he said, well, you said you were afraid. Who were you afraid of? Or something along that line. I'm paraphrasing. And she said the prosecution. Well, there is a case in the state of California that when you accuse the prosecution, I guess, of some form of impropriety, they have the right to defend themselves and to say that, no, they didn't coerce you in any way. They have a reason to defend themselves, and they actually were able to get that testimony in because of that. I believe probably the reason why the defense didn't have transcripts of it was because it wasn't going to go in. Like, they probably didn't even have I would assume they've at least heard what she said, at what Kelsey said at the police station. But the reason why it probably wasn't a transcript is it wasn't even going to come in. So anyway, the door was open. I know that was a long way around the mulberry bush, but I just wanted you guys to understand. A neighbor, now this is where we get to the neighbor. This is what tripped me out. When this neighbor testified, I was like, the neighbor testified on behalf of Tory Lanez. Like, he came in their case in chief. He didn't even come in the prosecution. He came in Tory Lanez case in chief. So a neighbor who was awoken by the shouting, Sean Kelly, testified that from the balcony of his home, his son and himself saw two women fighting and two men breaking up the fight. Then they saw GUN fire come from the passenger side of the car near the second woman. Okay. So of course there was a lot with Kelly's testimony. It was way more than that. Obviously, that's why we were like, why did he testify for the defense? They're alleging, I guess, his testimony somewhat changed once he talked to the prosecution, which I guess will make sense of why you would put him on, because he essentially put the gun in he put the gun in Tory's hand. Like he was saying, I saw the short one. He was calling him the short one or the little guy or something. And he was like, he had the gun, he was waving the gun all over. So he kind of put it in his hand. So it was more to that than that. But I get it. They're only pulling out what they need to pull out because they're trying to get their client out. Smith did not testify despite arguably being a key witness. Smith was not called as the people were not prepared for their cross-examination and asked to delay such testimony. Later in the trial, the people and the current attorney for the defense, Mr. Magdesian, stipulated that Smith was not going to be summoned. As the holidays were approaching and they feared that delaying the trial could cause a mistrial. Well, a mistrial would have been better than this guilty he got for 10 years. It was only through recent efforts that petitioner himself learned that Smith wished to convey and obtain the verified statement attached hereto as Exhibit 1. So according to Tory's people, Jaquan wanted to testify. However, because it was around the holidays, which it was because we ended up spending Christmas in California, his attorney allegedly stipulated that that's okay, he doesn't have to testify. That part just does not make any sense to me if it occurred that way. And because that sounds like to me an ineffective assistance of counsel, because there's no way in the world that you have somebody that can raise doubt and you're about to see what his testimony is. He said what he would have testified to under oath, that you wouldn't have this man testify. I don't care if we got to come back in February. If I haven't had anybody that really put on evidence for my client, why the person that I have that can put on evidence, I'm going to say, that's okay, I'll stipulate and just let them go ahead and not testify. Now, when you have ineffective assistance of counsel, typically the attorney actually they have separate hearings. And it would be interesting to see what Magdesian has to say as to this allegation that there was obviously there was a stipulation, but I wonder if Magdesian knew what his testimony was, because otherwise I don't even understand this whole portion of why you would stipulate not to have them testify when you really didn't have any other witnesses for real that helped your client. It doesn't make any sense to me. So, sound like a bunch of garbage. But anyway, I'm going to go to the affidavit after this because they have a few other issues in here, but because I told you it's 60 pages and we're not reading all of those, or a little less than 60. Smith did not testify despite arguably being a key witness. Smith was not called as the people were not prepared for the cross-examination. Okay, that's what I just read. Smith was going to testify to the following, as contained in his verified statement. Although Smith did not see if the petitioner or Harris physically discharged a weapon, he saw Harris in possession of such. Smith stated after he pulled the vehicle over, it was Harris and Pete who began to fight, to which he intervened. It was as Smith pulled Pete around the back of the car that he heard the weapon fired. The statement is new evidence as defined by Section 1473. Most importantly, this evidence would have most likely changed the outcome of the trial, as also required by 1473. The statement of Smith directly contradicts the testimony given by Pete, which also was not in concert with what was reported by Harris. Smith's statement comports with the testimony of Kelly. It is likely that Smith's statement would have tipped the scales in favor of the petitioner. So I'm gonna read the affidavit, and I want you guys to tell me if you believe that if Jaquan would have testified as to what he's saying in this affidavit. You know what? I'm not doing this with y'all. If you as a juror would have potentially found reasonable doubt. Now, what I thought was interesting, and they get on further with the petition, when they were calling this new evidence, and I do wrongful conviction. So one of the first things I said was new evidence. New evidence is typically information you were not aware of, and you actually didn't have any way of knowing, even doing due diligence. So apparently there was a law that changed in California, and they cited in this brief that they've expanded what new evidence is. Because in my experience, that wouldn't even be considered new evidence because he was actually there ready to testify. You knew he existed. You could have done whatever. So that wouldn't qualify. Now, as far as an ineffective assistance of counsel, I would agree with that. If that attorney actually knew this information or thought this is what he was going to testify to, I don't know what type of strategy. Ineffective assistance of counsel is very difficult to prove because a lot of times you're asking the court to challenge an attorney's strategy, what the court is not going to do. But there are some circumstances that just is so outside the realm that that couldn't be strategy, that you will get ineffective assistance of counsel. So here we go. Let's get down to the affidavit. Now, y'all, I want you guys to be respectful in the chat because I understand if there are people. This is one case that literally people are to the right or they're totally to the left. There are very few neutral parties when it comes to this case. They like, y'all see how long this is? Not doing it. But there's an issue with DNA too. So we'll kind of briefly go over that as well. But the big thing is I always wanted to hear I did want to hear from Jaquan. And now we finally get to hear what Jaquan got to say. So he says this is supposed to be the affidavit of Jaquan Smith, who was in the car the night of the shooting. He was the driver, and he was the only person that was sober on that night. Because, I had a theory that I thought everybody was just inebriated and nobody knew what happened. That was kind of my theory. I felt like nobody knew who did what, when, where, which way, or how. That was my theory. The whole pointing the finger at this person, that person, I didn't think anybody could prove either one. But the way the case went, because Meg said he shot me, I mean, that was direct evidence, and it kind of was what it was. And Tory didn't have any evidence to counteract that. So, affidavit of Jaquan. My name is Jaquan Smith. It has his address. I am over the age of 18, and I'm fully competent to testify. I have firsthand knowledge of the facts in question that took place on July 12th of 2020. That is the basis of the above cited proceedings. I was the driver and bodyguard of Mr. Daystar Peterson, who is better known as Tory Lanez, in July of 2020. Mr. Peterson has been known to me for 7 years. At the time of the incident, I had worked for Mr. Peterson for 3 years. He has not only been my employer, but I also consider him to be a close personal friend. Yep, I would have left that close personal friend out. Just me, I would have just said he was my employer. I wouldn't have said anything else at all. On July 12, 2020, I was asked to drive Mr. Peterson to the home of Kylie Jenner, where Miss Megan Pete and Kelsey Harris were present. Mr. Peterson was at Miss Jenner's home for approximately 2 hours when I received a call to come pick up Miss Pete and Miss Harris. Miss Pete, Miss Harris, and myself left Miss Jenner's home, but I was asked by Miss Pete to return because she stated that she had forgotten a shoe. When we arrived at Miss Jenner's home at this time, Miss Harris stayed in the car while Miss Pete exited. Miss Pete did not enter the home at this time as she went around the back to the pool area where Mr. Peterson was located. Both Miss Pete and Mr. Peterson returned to the car after a few minutes. Miss Pete was bickering, but I am unsure of the exact words she was saying. She seemed upset. The four of us left Miss Jenner's residence. As I began to drive, Miss Pete started fighting with Mr. Peterson. They were going back and forth. I remember Mr. Peterson saying to Miss Pete that he was going to tell Miss Harris what was going on. I do not remember what street we were on, but Miss Pete asked me to stop the vehicle. I did as she asked, and Miss Pete went to sit on a nearby bus stop. I think that was supposed to be Sunset Boulevard. They stopped. Mr. Peterson went and spoke with Miss Pete. After about 2 minutes, they returned to the car and I began driving again. Miss Pete started the argument again, and Miss Harris asked what was going on. Mr. Peterson told her that he and Miss Pete had been dating and intimate. Miss Harris was upset by this as she and Mr. Peterson had been dating in the same manner prior to any relationship with Miss Pete. Miss Pete and Miss Harris began fighting. I pulled over to stop them. Miss Pete and Miss Harris both got out of the vehicle and continued to fight, both verbally and physically. I broke up this fight and was pulling Miss Pete towards the back of the car. I saw Miss Harris with a GUN in her hands. Mr. Peterson ran from behind Miss Pete and myself towards Miss Harris. Mr. Peterson and Miss Harris began struggling as Mr. Peterson tried to unarm Miss Harris. I was still pulling Miss Pete and did not see who shot the weapon. I was lucky I was not harmed, and in my opinion, Miss Pete was also fortunate. The whole incident happened so quickly within just a couple of minutes. I wanted to present this evidence during Mr. Peterson's trial, but was prevented from doing so as the district attorney was not ready to cross-examine me. And later, they did not call me due to the holidays and the court schedule. I believe I should have been allowed to present the evidence at trial. Respectfully submitted, Jaquan Smith. So I'm going to say, what do you guys feel about this affidavit? So generally, when it comes to this portion of the habeas, they are alleging that this attorney, Jaquan, was prepared to give this testimony, and he was not allowed to give the testimony because apparently the first time he was going to testify, they weren't ready to cross-examine him. And then they didn't want to have to come back after the holidays. So they just stipulated that he wouldn't testify. If he had this type of information, do you guys believe this is reasonable doubt? I don't care. I'm not asking you guys, you believe he did it, Meg did it. Do you believe that if this information was given to the jury may have said, I'm not sure if it was Tory Lanez. It may have just been Kelsey that did it because he was the only sober one. Everybody else was drunk. Do you think this could have changed the trajectory of this trial? Again, it would have hinged on credibility because this is his friend. He said that in the affidavit. Meg said that he did it. So that doesn't necessarily mean that he still wouldn't have been found guilty. But it would corroborate some of the things that his lawyer was alleging we were going to see in a trial that we never saw. Really B said maybe it could have led to a hung jury. Okay. Renee said, I believe that it happened just like that. You said no. Okay. Reasonable doubt. I'm going to be honest with you. Well, I didn't like the way the whole defense thing went, period. I just did not like, I didn't like it. These attorneys seem like that are representing him now. Again, I was kind of semi-introducing them, but Unite the People are individuals that give low bono. They're a nonprofit, and apparently Tory has given a lot of money to them and has helped them pay their payroll and everything. And so now I guess they're returning the favor, because obviously all these lawyers that he's given money to, he doesn't have what he once had. He's not out here streaming like that. You know, his old stuff still come on the radio. I heard it the other day, but he's not out here making music. And most artists make their money through doing shows. So they have stepped in and they are representing him. And we know there are some alleged, I guess, financial issues, I guess, because at the sentencing hearing, that was brought up. That was brought up. Thank you, Mel Stewart. I appreciate it. Thank you so much for the $20 super chat. Okay, you said it was Tory's G. Okay. You said a close friend, but didn't show up till the end. I know, right? This is the same thing Sean Kelly said. Yes, Bars, I do agree that Sean Kelly's testimony coincides with Jaquan's. However, I also agree. I also, on the flip side, because I have to see both sides, we all know Sean Kelly's, not all, you know, I'm exaggerating, but most of us that have followed this case know Sean Kelly's testimony too. It's been all in the paper. It's been all in the magazines. He's not sequestered because he was not there. Sequestered means he wasn't able to hear the testimony. Now, if he was sequestered and he came back in, he may have clarified some of Sean Kelly's testimony, and it would have been more in, you know, it would have been beneficial. I think it's very interesting that now he has shown up and he said he's been friends with him all these years. I don't understand. It seems like when he did the motion for a new trial earlier this year, this would have been one of the main things that would have been in there. Like, listen, it was ineffective assistance of counsel. I want a hearing because I want this attorney to explain to me why this man would have at least put the gun in this girl's hand and he didn't testify, and you waived the right to testify over. I'm sure he would have suffered them 2 weeks over 10 years. That's how I would have said. Like, so you trying to say my freedom could have been hinged on this man's testimony right here? Because it wasn't like they was just in there winning, okay? It wasn't in there winning. I knew he was going to be found guilty by the time it was at the end of it. So it wasn't like y'all was in there winning like that. So you gave up a key witness that could have basically cleared up things, corroborated Kelly's testimony. You gave up that because it was the holiday? Like, what? If that's true, I have a sneaky suspicion that this defense attorney may not agree that that's how it happened. He may say he was told something totally different. Or maybe he'll get on board because he doesn't want Tory to be in jail. Who knows? J.I. said Tory said under an IG post Kelsey didn't shoot. Yep, that became a an issue in trial that actually was admitted as evidence. And they had a detective who basically said he was the social media guru, just nosy like we are all on there. And he talked about how you know that a IG page is verified, and he gave his credentials. It was just I could have been the credentialed expert on that. And basically, I think on cross-examination, the defense attorney basically said, you know, with a lot of celebrities, they have other people that run their accounts. Just like people are posting on Tory's accounts now. And before he was in prison, when he was just in jail, he wasn't allowed to he wasn't in Gen Pop. Like once he was convicted, he went to jail. So all the way through sentencing and all of this, he was in their county. So he was not in general population because he was a celebrity. So he was like where it was dark all the time, and they explained what the atmosphere was. He couldn't be around people and all of that. So I'm sure he wasn't on his Instagram. So somebody was basically controlling his Instagram. So that was their response, that perhaps it was not Tory who did it. It was somebody else who put that under there. But yes, that came up. It was actually under the shade room. It was a shade room where it was a picture of something talking about Kelsey. Somebody in the comments said Kelsey is the one that did it. And then from Tory's account, it said she didn't. So Barr said he just dropped an album. It went #2 behind Chris Brown on R&B charts, 28K first week. When was that, Bars? But Queen Diva said, wait. Y'all moving too fast. Wait a minute. Queen Diva, good vibes only. All those years that passed, knowing the trial was coming, there was no reason they shouldn't have been prepared for his testimony. Seems fishy to bring it up now. I agree. And you also have to these type of testimonies are scrutinized, and that's probably why there are other defects that his attorneys have added. This obviously is not, even though to us we're like, oh, we finally get to see what he would have testified to allegedly, it's still not necessarily considered a smoking gun, just because even a lot of times in wrongful convictions, you have people that recant, people that have they'll say, I testified against them because the police told me if I didn't, I was doing the time. And I was like, forget that. Well, what you want me to say? I just give me the lines, feed them to me, and I'll get him in trouble, but I'm not doing life. And that really does happen in real life. But because so many people recant, the courts do look at recantations differently. So based on this affidavit, although it's not a recantation, of course, they are going to scrutinize it probably with the same level that they do when people come back in an affidavit and say, I lied when I did this testimony. But I think it's very interesting, nevertheless. And I personally believe it would, if he testified to this in court, it would have changed a little bit of my perspective. I can't say that, because it's all about credibility. I think at least it would have gave him something. Because I felt like in trial, you had all of the people windmilling on the internet. Kelsey did it. What about the DNA? Every time somebody comments about this case under the post, they all just give me all the same talking points. Kind of like when with 45, everybody has the talking points that they do. And I'm like, talking points are cool, but come up with some evidence. Like, show me your evidence that you have. This is literally probably the first piece of evidence that I've seen that corroborates what half these people have said. Because the DNA situation about Kelsey having GSR, that was brought up in court. That's not new evidence. That was brought up. And that could have been explained too by the fact that Meg was in the back seat with her like leg on top of Kelsey. And she was the one that was hit. So you don't know like where this came from. They didn't have anybody talk about what was the likelihood that everybody would have had it. But the driver didn't have any GSR on his hands. So that information was brought up in the actual trial. Jaquan just alluded in the affidavit that Megan wasn't shot. Read it again. There were bullet fragments in her feet. So whether it was shot to the ground and ricochet or whatever was happening, I don't know. And maybe that should have been the defense. This is what my thoughts were about what happened. Of course, I wasn't there. I felt like everybody was drunk. I believe that Kelly, because he didn't have no reason to really like lie. He didn't know any of these people. I do believe that everybody was fighting. I believe that when he said it, because he just had no reason to really lie. He don't know you guys. He didn't even know who Tory was. And I believe it was a struggle with the gun. And I do believe that it went off. And I always just believe nobody really know who did it. And everybody was so drunk, they probably didn't know. And that was always my theory. But again, you had Meg that got on the stand and said she saw him do it. So that kind of was what it was. And that was evidence for the jury to make their determination. So you said very fishy. Mika 1991 say the testimony doesn't sway a thing. He said no DNA, no. Well, it was getting to the DNA stuff. Oh Jesus. Okay, we're good. There's a part on DNA. So is the document is legit? I'm not sure what you're saying, Charles and Jess. Thank you so much for the super chat. If you could just State what you were trying to say on the super chat, and I'll answer your question. This document came from, again, Milagro gave it to me, but it was this was filed today. There was a writ of habeas corpus file. I was able to go online, but they don't have it where you can download it like some courts. You probably have to order it to get it, or if you are a part of the case, obviously you'll get a copy. But they definitely filed a motion, a habeas corpus petition today. It was filed today. I was able to see that on the appellate website. Jaquan could have easily given Sean Kelly a testimony way before trial. Pam, can you give your opinion on why Sean Kelly's 911 call is under seal? I did not know that it was under seal. So you're teaching me something today. I didn't know it was under seal. I heard the 911 call. Doesn't somebody have that on the internet? I heard the 911 call. I want to say I did hear it in court. Andrew said, and Kelsey said he did it in Sean Kelly's. Well, Kelsey said he did it in the 80-minute interview. Kelsey changed her mind on the stand and said she didn't know who did it. So obviously, the jury believed Kelsey's interview, because you have to also remember when Kelsey did the interview, she was not by herself. Her fiance, I think it's her husband now, was with her. She had an attorney on the phone and she had an attorney present. So her kind of saying that she was coerced didn't logically make sense. It really didn't, because she wasn't by herself. It wasn't anything like that. And she was saying she felt intimidated by her testimony. But if you actually heard that 80-minute conversation, she didn't sound like she was coerced. She didn't sound like she was under pressure. She didn't sound scared. She didn't sound any of that stuff. Lucky 8 said that Meg lied. That's Lucky 8, Lady 8. So you said, so this document is legit. Yeah, it was filed. It was filed today. T Smooth said, yes, this was reasonable doubt. Okay. Gave up 2 weeks and got tenure, baby. I'm ready to put that on the shirt. I'm like, so you trying to tell me, isn't that what he's saying? Mika, like, isn't that what he's saying? Like, literally, I gave up 2 weeks because you would have had to come back after the holiday. That's like what's happened in the YSL trial. Because someone got injured, they don't want to do a mistrial. And so, and honestly, he might have been better off with a mistrial, because then he could have recouped. They showed their hand. You know what the prosecutor is coming with. Now you go get a legit, for real defense team, because we know Sean Holly was supposed to be the attorney beforehand. And according to letters that leaked, Sean Holly told him the whole Kelsey defense was not a logical defense. And I'm going to assume, see, that's another thing that makes me believe that Jaquan never said this before. Because if she would at least had this, she would have knew that there was some type of testimony to corroborate the whole Chelsea defense. Because it's reasonable doubt on whether maybe Meg was mistaken and she thought it was him, but they were really wrestling over the gun. Like, that would have been a better defense than pointing it to Kelsey, and you really didn't have anybody that was going to say that Kelsey did it. It's not what you say. What we say as attorneys, it may sound good. We try to persuade you and say whatever, but they'll tell you in the jury instructions, what we say is not evidence. The evidence is the testimony, the physical evidence, DNA, what the experts say. That's evidence. What we say is not evidence. Andrew said it's not under seal. You said, yeah, it's sealed. And they said you need a court order. Really, Rally Sunshine said it is. Okay. I'm not sure. J.I., thank you again for the super chat. You said, I don't trust the source. Milagro lies. You know what? She is definitely she's a pro Tory person. I've had good encounters with Milagro, so I don't have anything negative to say about her. And again, I asked for the document. I'm like, can I get that document? Because I want to read the whole thing. Because I did see that she posted the whole thing or whatnot. But no, there was definitely a filing today. It was a habeas. She is in um as you guys know, Milagro has some, she talks to, I think, his lawyers, perhaps. I don't know how deep the conversations is. I don't want to put anything like that out there, but she's in contact with his attorneys and probably the family as well. So I have no reason to believe that somebody just typed all of this work up and it ain't legit and it wasn't filed. I have no reason to, but there's a lot of work. Mika said, why Jaquan never give an interview? He could have been had his testimony on the record. I believe her interview. TD said, I believe her interview was fresh and she was still emotional. Okay. Rally Sunshine said, y'all don't know it's under seal because a lot of y'all waiting on Megan Cunim to report on it. You on punishment, Rally. On punishment. You on punishment. I don't know. So if I don't know, I'll say I don't know. But I feel like I heard the 911 tape in court. So maybe you're saying it's under seal, like they're not allowing it under the Freedom of Information Act when people are asking for it, or they're requesting it or something, because maybe it's further investigation or something. If something is under investigation, they don't release it. Why do you think, like, for those that follow the Krishan and James Wright Chanel and Tamar issue, that 911 tape would have been out here. TMZ would have been had it, or somebody would have been had it. The reason why is because they're not releasing it in LA because it's still considered investigatory. So apparently there's still an investigation going on. They have actual statutes that they don't have to release what a lot of other states release in California. Because I looked it up on a couple of other cases where I was trying to get 911 body cams. They were like, that's not even something that just gets released. We get them like that. It's like, what? Unless they just, turn them off, or they say they were broken or whatever. We can always get like dash cams and body cams, and some, as counties in Georgia, you can actually get the prison call, the jail calls. Those are released. But California is very strict on what they release to the public. So I don't know if that has anything to do with it. But Charles said, I think Kelsey listened to Meg's take over the years and gathered what she say in her given testimony based on the story Meg was given. How can years later y'all remember the night so vividly? That's from Charles and Josh. Well, part of that too, you also have to realize too that Kelsey and Meg were no longer friends. They don't talk at all. Kelsey did a diss tape or diss rap or whatever on Meg. Nobody liked each other in this case anymore. So that's what made it very interesting too. Like, nobody was really friends. So again, Kelsey she wouldn't root for Meg and say, yeah, she did it. Yeah, and still Kelsey wasn't gonna blame herself and say she did it. So she just kind of said, I don't know who did it. She didn't want to help her for sure, but she didn't really want to help him either. That testimony was just a waste of time and space. Karen said maybe the pressure Megan felt was from her fiance. Yours truly said during the 8-minute convo, they had to keep reminder of her that they wanted to know about Tory. She was fixed on Meg. That is true. Lulu Richardson, Robichaud said Richardson. Lulu said defense arrested because of Christmas. That's what the affidavit said. Am I missing something? Relly said a lot of us thought that Tory was going to beat the case. But why did you feel that way because of how it was being reported to you by the media? Because I think a lot of the misconceptions is just because a lot of you did not know what was going on in the courtroom. So that's just like if you guys are following YSL. Like I follow, let me go back to the Melly case. There were a lot of things that we saw as non-jurors because it was streaming that they weren't allowed to get let in that would have been detrimental to Melly in that case. But because they weren't allowed to let it in, of course, they ended up with this hung jury. But there was a lot of stuff that would have been detrimental that if the state finds a way to get it in this time, it may not be good for him. And he's facing the death penalty. And that's how it is when you're sitting in the courtroom. That's why I say it's very, very important to have like a non-biased person. And then people pick and choose what's important. So everybody wants clickbait. So they go into court and they're like, oh my gosh, Tory was sleeping with Kelsey. They were sleeping together, and then Tory left and started messing with me. Like that's what the clickbait is, because you're like, oh my gosh, that's salacious. For me, I don't care. That was like a red herring in the case. Like I didn't care. I wanted to hear evidence. Where is the person from Rock Nation that's gonna sit on this stand and acknowledge that they offered this man a contract and he turned it down? That's all I would have needed them to say just to start developing my theory. Where is the person again? I kept asking, where is this security guard? Where is the bodyguard? Like, it to me, it felt like there was no way this bodyguard could not testify. I felt like he needed to testify. Him and Juan. Juan was Megan's bodyguard at the time. He didn't show up. Remember, he had like a bench warrant. So he didn't show up. So it sounds like there was conversations about Jaquan being able to testify, but they were like, we don't want to wait till after the holiday. If that was really the reason, that's awful. That's awful. So yeah, anyway. Sean Holly discouraged Jaquan pinning it on Kelsey. She said it wasn't viable, meaning she was working on a TV show that had Jay-Z music in the titles. You know what? Really? Y'all with this Jay-Z stuff. You guys are hilarious. Empress says Sean Holly only did because Alex Spiro threatened her and accused her of bribing. Now, there was some issues about allegations of bribery, but Sean Kelly had actually stepped. There was another woman that was with Sean Holly. So I don't understand why the other person that Sean Holly wanted to be a part of it, why didn't she still take over the case then? So I get what you're saying. He said she was worried about her career and didn't want her name to be mixed up in that. Charles said, I think Kelsey listened to Meg's takeover. Oh, okay, I read that. Sorry. Okay, let me catch up. Let me go down here. I'm clearly way behind. Okay, so allegedly they're saying Tory did not get on the stand according to other documents filed by his attorney because he didn't feel comfortable because he was advised that his lyrics and his songs can be used against him. That is the price you pay when you try to litigate in the media. As you guys know, Tory had the videos that he did allegedly of Meg, where he was talking about Meg. And, a lot of his postings has been an issue. He had bail revoked at one point because of his posting. He just needed to stay off of social media. He was trying to litigate to impress you guys, the fans that love him. And I think he should have kept it in the courtroom. And that worked against him. That worked against him in this case. Really B said, this is how that happened. Meg stuck to the story until the rays came back and the doctor told the police that she had bullet fragments in her foot. That's what she said. She said, so apparently with the glass, how Meg testified is she didn't deny that she lied. And she probably told the police that report that there was glass in her foot. But she had to go get treated because she's bleeding all over the place. If you guys saw the body cams, the pictures, it was blood everywhere. It's blood in the car. She was bleeding. And so she had to go in and actually get surgery And I mean, the doctor took what was in her foot out. So whether she said it was glass, what she said, whatever it was, they're gonna be the ones to analyze and say what was in her foot. And so she said she lied because she didn't want to get anybody in trouble. So perhaps if Tory didn't go on social media, she would have never said anything about it. I don't know. Coulda, shoulda, woulda. Hindsight is always perfect vision. Man, we think we doing it, Crunk Girl 711 over here on YouTube, but yeah, it's definitely different. We just give our opinions, but at the end of the day, like I tell my clients, you got to do this time. Stop listening to what other people say, what they think you should do. None of these people are going to go with you. None of these millions of fans, none of these people that streamed your music, none of these people are going with you. So can you be quiet until trial? Y'all don't see ASAP Rocky out here talking, do you? Like, can you just be quiet? And a lot of these celebrities are in different litigation and you don't know anything about it. Mariah Carey been in litigation with her brother since like 2020 over her book. Do you hear Mariah out here talking about her brother? Can't believe he sued her, talking about that she slandered him in a book. She is still currently in litigation for the last 2 years and don't nobody know nothing about it. This stuff with Sean Combs. You think he ain't never settled a lawsuit before today? Or before Cassie? It just wasn't talked about. This litigating, and I understand when you're a public figure, and this is what I tell some of my people. It's like when you're a public figure, you don't want your reputation smeared all over, but you need to have a PR person that can handle the public, and you don't show your hand and don't show your evidence, and you stay away from social media. Like your life is on the line. 10 years is a long time. That's a long time. 10 days is too long in jail. What does I don't know what. No, I'm not. Okay. I'm take that down because I'm pulling partial comments. Tory should not have said nothing. I don't care. I do not care if Meg said whatever was said because at what happened is at that hearing, the only thing that was put up there is all of what the media and stuff was saying about Meg. There were hate pages people put up about Meg that got some of y'all names that are so pro Tory probably was in the trial and you don't even know it. They were pulling up pages of people, comments of people saying you a liar. Why you do this to this man? I hope you die. Go hang yourself. Go jump off a bridge. Go cut your feet. I wish he would have just blew your brains out. I mean, it was horrendous. It was horrific. I just couldn't believe. I was like, this is this deep on social media? Like what? And then you get out as the person who they're defending. Anything you say sounds like you're endorsing what they say. He did not take the stand. So she was able to show all of the hate she got. You think that didn't sway a juror? Black auntie with no kids said, what is the reason they want Tory in jail? Am I missing something? I don't know. It's some theory about Rock Nation wanting to sign him or something, and he didn't want to, and this was like punishment. Y'all can help me out, auditory fan, because I've heard so many different theories. And again, I wanted to talk about the affidavit because this was really like the first piece of like evidence that they've had, even though it's been a day late and a dollar short that they decided to come up with this evidence. But Steph J said Jaquan is lying. Okay. Glitz England said, I honestly don't believe Tory did it, but I've been wrong before. I don't know who did it, child. I don't know. Man, Jeff said 10 minutes is like the death sentence if you never been in jail. Yes. So that's what I'm saying for the reasoning for him not to testify and give this information, because at least if nothing else, they might not believe Jaquan, like somebody said. They may not believe him. But at least you got somebody that's somewhat corroborating what's being said and what your attorney is alleging occurred. You don't want to wait 2 weeks because of the holiday? Oh, I just hope that's not the case. And again, if there's any ineffective assistance of counsel, that attorney is going to have the right to take the stand and give his reasoning. That's a whole separate hearing that they have specifically for the attorney. Sweet Jane said Tory was an absolute idiot to speak on the case and making video about it is straight foolish. Thank you. I'm just saying. Public opinion can only take you so far when jail is involved. Listen, I don't care what none of y'all say. If you talking about locking me up, I ain't got nothing to say. You can be in the chat like, Pam, but what about so and so? And then you show your hand. Like a lot of people show their hand to the other side. The prosecution used a lot of the stuff on social media in their case. So you think they didn't know about they didn't see half of the people on the internet that were pro-Tory and all of their theories and conspiracies? You think that the prosecution didn't know that? And so they took that information and they made sure they were ready to combat it. Even if it was to get defense attorney to stipulate to not having Jaquan testify, which is, I just can't believe it. It's just absurd to me that an attorney would do that. That's just my opinion. They should have put up contradicting IG lies. Lucky 8 Lady 8. They should have did anything. But it just, if you were in the courtroom, and I understand the people that are pro-Tory, if you were in the courtroom, all I can report is what was admissible. That's it. All of your theories may have been 100% correct, but if you can't prove it, it's not what you say, it's what you can prove. If you can't prove it with admissible evidence, then what you're saying means nothing, is all I was saying. If nothing else, I think that's what people learned about this case, that really do believe that Tory is innocent. I get it. You guys saying he should have taken the stand. Most defendants don't take the stand. It's a gamble. But at the end of the day, even though they say, they tell the jury, you don't have to testify, you have the right not to testify, and you can't use it against my client. When you talk to jurors, they do want to hear from the defendant. But most of the time, because the defendant does not have the burden, they are not placed on the stand. And I think Tory did want to testify, and I believe that's what he said, that he did want to testify through somebody or on one of them calls. Remember, he released some calls after he was convicted. Apparently, Tory is an independent artist, so it's possible. You said I said Jaquan is lying. I agree, Tory is not that relevant to be doing all this lying. No way. Ray Bishop said, I've been listening, but I feel like this isn't one bit credible. Okay, guys. I got it. So that is from Jaquan. Let's hear what they have to say about this DNA. So there was some DNA since somebody brought it up. Apparently, let's see. So we heard from Smith and we read the whole affidavit. Forensic testing did not resolve any questions of who the shooter was. Both Harris and petitioner had gunshot residue on their hands. Inexplicably, considering these GSR results and the wildly conflicting testimony versions of the events, The only DNA sample collected for analysis in comparison to the firearm and magazine was a sample belonging to petitioner. The test results ruled petitioner out as a contributor to the DNA recovered from the magazine and were inconclusive as to the gun. So that was the DNA where he was basically ruled out when it came to the actual magazine, but it was inconclusive as to the gun. So they couldn't include him or exclude him. In advance of trial, the people only partially disclosed evidence related to DNA testing, despite the exculpatory and material nature of the evidence contained in additional reports, belatedly turning the more complete version of the evidence over only on the request of the defense expert. The DNA evidence admitted against petitioner failed to comport with industry accepted standards in violation of petitioner's due process rights, thus resulting in a miscarriage of justice. At trial, the people introduced evidence that petitioner could not be excluded as a contributor to the DNA evidence collected from the firearm recovered in the SUV, though his profile was conclusively excluded as being present on the magazine. So they're saying the people introduced evidence that he could not be excluded as a contributor on the firearm. Specifically, the people's expert LAPD criminalist Randy Zepeda testified that the DNA profile of the swab of the handgun was a mixture of at least 4 people, including at least one male with mixture proportions of 90%, 5%, 3%, and 2%. He continued to testify that for the 90% contributor, that's an unknown male, male 1, so it's definitely not Mr. Peterson. As to the other profiles, the expert testified, quote, the contribution of Mr. Daystar Peterson was inconclusive. The statistics don't support inclusion or exclusion. That's just a neutral result. However, the people pushed the issue further, attempting to stretch the expert's words and asking, quote, so Mr. Peterson can't be excluded as one of those individuals, end quote. To which criminalist Zapata replied, he can't be excluded or included. It's inconclusive. I can't really say anything to his inclusion. When asked on cross-examination, quote, can you sit here and say petitioner's DNA is on the gun? The criminalist replied, no, it's an inconclusive result. So I'm not making any conclusion as to his inclusion or exclusion. However, when further asked, quote, but because you can't give us any conclusion, it's fair to say he is excluded, correct? He again responded, no, it's a neutral result. This is exactly how I went to. It was so redundant where he was saying the same thing. Like, I can't exclude him or exclude him. Like, I'm not including him. I'm not excluding him. I can't really tell you what it is. I couldn't give a result. It wasn't enough. No, it's a neutral result. He is not included or excluded. Based on the results of the analysis, he stated his conclusions another way. He was unable to say, quote, that defendant touched the gun, end quote, or that defendant did not touch the gun, quote. When asked to further describe the nature of his analysis, the state's DNA expert described their STR mix method as comparative, stating his job is just to make comparisons. However, the DNA on the firearm and magazine notably and questionably was not compared to any other persons in the vehicle at the time of the shooting. Criminalist Zepeda also indicated he did not have comparison swabs for anyone other than the petitioner in this case, and specifically not for Harris. So the expert did not know if Harris's DNA was on the magazine of the gun. The defense called their own DNA expert, Mark Scott Taylor, a forensic scientist affiliated with the non-accredited Technical Associates, Inc. Scott agreed that with regard to the DNA evidence on the gun, he could not, quote, exclude Mr. Peterson, but there was also no evidence that Mr. Peterson touched the gun, end quote. And when asked if Peterson's DNA was on the gun, he unequivocally answered, quote, not that we can tell, no, end quote. He similarly testified that, quote, it would be surprising to him if petitioner handled the gun and his DNA was not on it, end quote. And the result in this case, quote, literally means that we can say nothing about whether his DNA is in fact present, end quote. A conclusion he opines did not inherently different from the state's expert. Scott did, however, note that it would have been the standard practice, quote, in a case like this where there's a shooting and there may be some confusion to collect the DNA sample from everybody that there had an opportunity to hold the gun, to shoot the gun, end quote. However, Mr. Scott failed to ever memorialize any of these findings in any formal report or documentary form. That petitioner's profile was unable to be excluded was critical to the people's case against him, as there were many conflicting versions of events and issues regarding both ownership and who discharged the firearm. Specifically, they stated in their opening argument that out of the 4 profiles found on the gun, quote, he could not be excluded as one of those people. Okay. The people reiterated this position in their closing, expressing as to the gun, quote, my expert, the expert from the accredited lab, said that if you fire a gun, you may see DNA. You may not. We just don't know. But don't be fooled by an argument that the defendant's DNA was not on the gun, because that's just not accurate. And we're seeing attempts to mislead you. And I don't want that to happen again. That is not accurate. So for those that care about the DNA, this was their argument, arguing, and both experts pretty much said the same thing, that when it came to the actual gun, there was no inclusion or exclusion of Tory Lanez. However, there were no other people that were swabbed either for DNA. So that means that Kelsey wasn't swabbed, Meg wasn't swabbed, none of that. Now, there were GSR, as you guys heard earlier, and that was found on Kelsey's hands. And it was also found on Tory's hands. So, yeah, I don't understand that argument. So I'm just going to, Yeah, they did. I agree, Dev. The LAPD did a very poor job at investigating this case. Yeah. Glitz England said essentially he got 10 years over. He said, she said, the only scientific evidence could not include nor exclude him from the weapon. Well, testimony is he said, she said, if you want to put it that way. But it's direct testimony, because if I say what you did to me, I'm a witness. Like, I am a direct witness and I am evidence. Mm. You said, Mika said, yes, that, but see, I think what they're trying to argue is, they being the state are trying to basically argue that the way the state was presenting it wasn't necessarily true, because he's saying he couldn't be excluded. But that's their job. They're not going to say he couldn't be excluded. Oh, and he couldn't have been included. Like, they're not going to say that. That's the defense's job to say, you heard from both experts who agreed that there was no DNA from my client that they can say was included or excluded on this gun. But then you got all type of theories that people go on, that the gun was in the car. It could have been wiped down while it was in the car. They found it by Tory. There were other things that also, other facts in this case as well. But so that is their other argument that they have on their habeas. I don't know if these are the same arguments they're going to argue on their appeal. So they basically say Senate Bill 97 updated Penal Code Section 1473 to further define new evidence so that petitioner may show his innocence through a statement of an unheard key witness. That's what I was saying at the beginning when I first saw it. I'm like, that's not considered new evidence. But what they are saying is there is a Senate bill that updated the penal code where new evidence is defined differently. So they say, as approved by the governor on October 7, 2023. So this was literally just a month, 2 months ago. They expanded the definition of new evidence as found in Penal Code Section 1473. Relief through a writ of habeas corpus was previously only permissible if said new evidence could not have been discovered prior to the close of the trial. As it stands today, Section 1473 now includes new evidence that, quote, is presented without substantial delay, is admissible, and is sufficiently material and credible that it more likely than not would have changed the outcome of the case. Furthermore, quote, new evidence is now defined as that which, quote, has not previously been presented and heard at trial and has been discovered after trial. That has been discovered after trial. No, I don't know about that. Smith was not called at trial due to the ineffective assistance of defense counsel in agreeing to first delay in calling Smith and then stipulating that he would not be called upon request of the people. It was unknown until this time that Smith had witnessed and what he would have stated. So I agree as to the ineffective assistance of counsel if it happened the way that they said that it did, as I told you guys before. Now, the second part of it where they're talking about it was unknown until the time, why would he testify if y'all didn't even know what he was going to testify to? If he was previously a witness in the case, why would he testify to something, even if Magdesian had called him? I would presume he knew what his testimony was going to be or had talked to him at some point. So I don't know about this whole new evidence, but I do think ineffective assistance of counsel might be something to explore if it happened the way they said that it did. Right. They knew they had him on the witness list. That's why I'm saying I would assume they knew what he was going to testify to. That's why I'm saying if he was going to testify, I presume whatever he was going to say probably was going to be favorable to Tory if they were going to call him, but they must not have thought his testimony was just that great or that was going to be that persuasive for them to agree that we don't want to delay the trial for 2 weeks. That's crazy to me. When somebody is facing this type of time and you're like, oh, 2 weeks is an inconvenience. I want to go caroling with my family. Like, how does that work? But again, that's only if it's the way I'm gonna see how this unfolds because this is crazy. Have you guys gotten your tumblers? These are your Law Intellect tumblers. Go hit that link over there. Grab you a tumbler. Black Auntie said he is apparently the linchpin, and yet they said never. You know what? Teresa said his lawyers thought they had the witness in the bag, but he switched up after the DA briefed him. Who are you talking about? Which witness? Are you talking about Sean Kelly? Because I heard Tory's dad did make that allegation that that I think it sounds like Sean Kelly probably would have testified as to the fight because he did say that on the stand. But I'm pretty sure they never heard the whole allegation that Tory had the gun at some point, was shooting up in the air. I'm pretty sure they didn't know that because I want to put them on the stand just to say they fought if they were going to put the gun in my client's hand. When I seen that, I was like, woo. When I heard it, I was like, oh, I probably made a sigh in the courtroom. I'm like, what? You guys, and you put them on the stand as the defense? If they can tell the DNA is male, not testing the woman's is mute. That's not what was said, though, sweet Jane. That's not what was said. So what was said was how they did it was they can tell there were different DNAs on there, and they can tell that one of the people were male, and at least, they can tell a certain amount. And there's got some X, some Y chromosome, if you went to biology. So they just couldn't tell like how many women it would have been, how many men. They could just tell you that it was some male, it was some female, it was all over the place. It just wasn't really beneficial for either side, in my opinion. Yours truly said, I don't think they thought it would affect him. Shooting in the air didn't mean shooting her. But I'm assuming you're talking about Sean Kelly. Um, but if you're talking about reckless, you got to look at his charges. So if you look at his charges, you can have reckless discharge of a firearm as well. That is a charge. And he got that as well as a negligence. You don't even have to have intent to actually hurt anyone. So that wasn't going to help him either on one of his charges. And the fact that you were in possession of it, that doesn't take away the possession either. It's like him putting in his hand basically satisfied the GUN charge that he had, even if it didn't satisfy the other one. And he's from Canada, so he was risking deportation, which is another issue I had, that I didn't understand why an immigration attorney was not involved in a lot of these moves that were made, because he is a Canadian citizen. And there was no immigration attorney that was anywhere involved in any of this stuff. Yep. They added that right before trial, I believe. They added that reckless discharge right before trial. But I mean, as a defense attorney, you know that it's out there. Like, you tell your clients, like when you do preliminary examinations, that's why some people choose whether they want to have them or not for various reasons. Strategic, that some people waive them. Because sometimes when you get done doing your probable cause hearing, they add more charges. You might get lucky and get some dismissed, but you might get some that's added. They can always add more charges. So as a defense attorney, you think of all the way around what charges they can try to charge your client with. Why did Meg and Kelsey lie about fighting each other that night? They both lied about the fight. Based on Sean Kelly, there was a fight and they both denied that they did it. I don't think Sean Kelly has a reason to lie. So I would err on the side of Sean Kelly probably wasn't lying, that they had some type of altercation. No, he is in jail for, let's go back to the top. Let's go over his charges right fast. This is like another case that never ends. Because again, I was in court around this time. Okay, so on December 23rd, 2022, petitioner was convicted by a jury on count one, assault with a semi-automatic firearm, personal use of firearm. B, assault is just that, the intentional touching of unwanted touching and intentional touching of someone. Finding the assault have been committed through use of a firearm, causing great bodily injury. So they went through all of the great bodily injury and what those prongs are. Count two, having a concealed firearm within a vehicle, not registered, in violation of the penal code. And count three, discharging a firearm with gross negligence, in violation of the penal code. And then it caused injury within the meaning of the penal code. And actually, you don't even have to cause injury under one of these statutes or for the aggravating factors. Tamika said, it's funny to me that all these people windmilling, but Tory still haven't told y'all what happened. He's accused of state of wrongdoing, but still haven't told his fans. Yeah. We just trying. We just great bodily harm was because she did have to have surgery. Surgery is all, and this is how they presented it. You have to be under anesthesia. You had to be put to sleep. So clearly there is an invasiveness. She also still has some fragments still in her foot, because all of the fragments could not be removed because of where they were. Like, they didn't want to mess with nerves and all of that. So they removed some of the bullet fragments, but not all. So she is to this day still walking around with some fragments as a reminder of what occurred that night. So You said, let me see. Please, y'all hit that like button. You said Tory took the gun out of Kelsey's hand when he admitted Kelsey didn't shoot Meg. That's an interesting theory. So you think he took the gun and did it? Or do you think it was just an accidental discharge? Could you agree that maybe he didn't intentionally? Now, Meg's testimony is he said, dance, biatch, dance. That's her testimony. So that would make it intentional. So I think a better argument would have been it was unintentional. Her argument was that it was intentional. But really, there's nobody that really can say for sure, based on what we have, even what his affidavit is, that Kelsey did it. It could have been either or based on this affidavit, but either or is reasonable doubt. He said, I don't mean literally took the gun. I mean legally took the gun out of her hand. He said Kelsey didn't shoot Meg. Oh, I got you. He said, Aaliyah TV said, I don't believe he said that she was drunk and out of it. Okay. Ah, Tamika said that's his problem talking on a freaking album and not in the court of law where it matters. But go on. Man, listen. And then this is the bad part too with Tory. Not only was like they admitted a lot of the stuff that happened on social media. He had bail problems, and then he had the issue with he got into the altercations with people while he was on bail. Then he showed up at the Rolling Loud or whatever that big concert is called, and while you knew she was there and you had a restraining order, it was just dumb moves that were happening. That was like, why are you doing this? And like for any of your supporters to cheer you on and you get gassed up is ridiculous to me because again, your supporters are just watching this. They're hashtagging free Tory. They might buy a couple of t-shirts, but they don't have to do that time. You got to do that time by yourself. So I think there was a level of immaturity there. I'm sure this has matured him a lot. But and then while he's awaiting sentencing, he did the phone calls that were on the Shade Room, where he basically talked about the DA. He talked about them withholding exculpatory evidence. All that stuff was used against him for the sentencing. Even if you felt that way, tell your lawyers to put it in a pleading. So it's not, so yeah, if we read it online, it's just us reading it online or whatever and giving our commentary. But you putting it out there, know you got hundreds and thousands of fans. They rightfully were like, you're putting a target on our back as the DA by saying we're lying, we're withholding exculpatory evidence, the DNA test. I still don't understand the DNA test argument because it is what it is. You're not included or excluded. So I don't even understand why we still arguing about that. But apparently they still are. But it's like that got used against him for the sentencing. The DA was able to use that against him. I don't even get like why people aren't understanding that a lot of, if you support this man, support him by, if he got some type of financial GoFundMe or again t-shirts or whatever where he can get the adequate representation and the adequate, because he needs some PIs to find new evidence. You need investigators. You need not that is investigators, but you need so many different people when you try to do this type of post conviction work. How about you spend your money doing that instead of gassing this man up, and then he get out here and feel like he gotta appease his fans because you don't want to lose your fans, and it's not really helping. Thank you, said CDC say he got a parole hearing May 6th of 2029, 5 to 6 years, he'll be fine. I love you. Thank you. But yeah, he already did a year. And then I think it's projected he would have did like 7 or 7.5 or something like that. So You said most cases don't involve DNA, and DNA evidence has only been used in trials for 25 years. That's why you have so many wrongful convictions now that are being overturned because the science has evolved. And so you had old rape kits, you had all of that. I'm sure you guys watch Law and Order, where now they can retest them because of the evolution. Listen, right. Tory can hire me to go to Cali for a month and investigate. And Deb will find them. Deb will find whoever it is, if it's a witness, whatever ring cam that's out there. He is really good at his job. Yep. He will probably be deported after he serves his time. Yep. I agree. But yeah, he'll probably do like 6, 7 years. I don't care. Like I said, 10 minutes is too long. And especially if you're saying you didn't do it. And a lot of this is because you just couldn't be quiet. You had to let the work. Like, do you just feel good that people are out here windmilling for you? Or do you really want to win? Like, find your evidence. Like, I'm innocent. Let me get out here and get to work. He said, honestly, though, all three of them committed a crime that night. It's wrong to consider one crime over the other person because they all committed crimes. That wasn't the defense, though. That wasn't his defense. So I get what you're saying, and I agree. That was my after I heard everything, I was like, I don't even think they really know who did what. I said, I think they were so gone, they were drunk. I'm assuming it's alcohol, whatever. I said they were blown. they had EJ testified on how much drinking they were doing and the bottles they were taken to the head and all of that. Even like Meg's story didn't even match up. I think it was with Kelsey's story on how they got in the car and when they came back. And because I don't think Meg said they came back for the shoe or whatever it was. I don't know. It was just so much all over the place and conflicting evidence on what happened. I think most of the testimony that was conflicting is because it was alcohol involved. I thought it was very interesting that Kylie Jenner got a pass. She didn't have to testify. All the other people that were there, they didn't have to testify. EJ also testified that he saw something that looked, not really. I don't know about that. I think that's what they were trying to allude to, but that's not what I got from that testimony. They were kind of saying, you don't know what was in the bag, right? You didn't look in the bag. Did you go through it? Did you notice any? They were able to say that once they went through, because he put their clothes in there. So he only dealt with like Meg. So he knew what wasn't in her bag. But obviously he didn't know what was in Kelsey. So there were some alluding that she may have had a weapon in her bag. Right. Kylie Jenner said no. And remember, it was headlines at one time where they were saying Kylie and what's the momager Chris's boyfriend, he was there earlier that day too. And it was like some headlines that they may be subpoenaed to testify or something. I think they were put on the list. I said they skated out of that one because they sure didn't show up for that. They sure didn't have to. So if the people wanted Tory, they could have deported him in his prior cases. I'm not buying the man is after Tory. That's true. Tory had another case that came up, but he got a diversion program. He was caught with a GUN, and I believe it was in Florida in Broward County, and he got a diversion program, which basically means that when you do whatever they tell you to do, they dismiss the case. So it's like it never happened. It's like an automatic dismissal of your case. So he did whatever it was. A couple of months later, he was able to get it dismissed. That came up in the trial as well, and the defense was beating the tables because it came up because it shouldn't have came up. That should not have came up in the trial that he had that case. But yeah, you're right. They could have offered not to give him that type of a deal. Y'all gonna go. I don't want y'all arguing over here about Tory. We just going over the case. That's it. So that was it. So that's their theory. They're saying that it was new evidence. I just want to make sure you guys know the whole theory. You guys heard about the DNA and all the complexity. They go over that all over again. I'm trying to see what this next thing is before we get off of here. Who'd have thought I'd be talking about Tory today? Is that it? Let me see. All of that was about DNA. Assembly Bill 518 allows a court to sentence petitioner to a term pursuant to count 2 or count 3 while staying the other counts. So not this, they're also challenging his sentencing, saying that he could have got a less amount of sentencing. So that's another thing that they're challenged. They're also talking about Assembly Bill 124. A court must impose the lowest term possible when mitigating factors are present. And as such, must be applied to petitioner's case at hand. Another thing that they are arguing is Senate Bill 620 gives courts discretion to eliminate the GUN enhancement, such as that which was imposed in petitioner's underlying trial. Oh, that's discretionary, so he could have done it. Assembly Bill 256 allows considerations of bias or discrimination based on race, ethnicity, or national origin as what petitioner faced through the criminal process. That's interesting. I'm trying to see the facts they're alleging that were racist. In petitioner's underlying trial, it was found that one of the reasons to deny him bail pending appeal was that he was an immigrant and facing possible immigration issue. It is just such considerations with the RJA was enacted to prevent. Ah, that's interesting. So they're saying he was discriminated against because he was an immigrant on his bail, because they were saying because he is an immigrant is actually a reason not to give him bail because he could just go ahead and go back home. That's interesting. They over there working at Unite the People. Okay. All right. Mm. Petitioner prays that this honorable court of appeals will consider the historical treatment of minorities through the penal system and find he has met the prima facie standard to provide him an evidentiary hearing on the enhancement that petitioner received, which is met out to minorities at a much higher rate than other ethnic groups. Interesting. Very interesting. Leah said, I'll flee the country too. Back to the Trinidad I go. I had a case where a client, oh my God, it was crazy. I forgot where he was from. This was when I was doing criminal. And he did like he was on bail, and he actually, like, all of a sudden we get phone calls because he done drove to like Philly or something to take an international flight back to his country. And the judge was like, you better be here in the morning for a trial, or, the consequences. And he drove all through the night and had to come back. He got caught trying to get on the flight. So that does happen. You said, before you go, I'm wondering, are you going to cover the Usher versus P. Diddy case in another live? I don't know about the Usher P. Diddy case. Was it a lawsuit or something? Thank you, Karen, for the $5 super chat. I appreciate you. What happened to him for the August Alsina assault? From my understanding, there was a civil lawsuit that was settled. From my understanding, I don't think it was ever anything criminal. Thank you for the super chat. You know what? I have kind of been staying away from some of the Diddy stuff until I get a response. That's kind of why I've been quiet, because I want to see some of the responses. We got LA Reid. I want to see his response on Diddy. I want to see some of the responses on Jamie Foxx. I want to see the response. So I kind of been staying away from them because it's just going to be more. The more lawsuits we have, the more we got to keep going over them here, and these motions that come and deal with it or whatnot. Now, what has been interesting is the bodyguard, Roger Bond, who was Diddy's bodyguard. You guys, we were following him for a minute, but then I came to the conclusion that a lot of his appearances was his son is, according to him, wrongfully detained in another country. And it felt like he was trying to get money. That's what it felt like. I mean, it's his son, do what you got to do. But then a couple of days ago, he actually came out with a post where he said he did an interview. I don't know if any of you guys saw the interview. I have not seen it yet, nor have I looked for it. But he allegedly, I guess, did an interview with somebody. He said it was my one and done. I'm not doing anymore. It's all about my son. Now I'm back to my son. Then an hour later, he puts up a post and says, I'll do any of your podcasts for $25,000. That'll stop you guys from asking me to do interviews. I bet you I have radio silence or something, but it's all for my son. So it was like, I just was over it. I'm not saying that he didn't. A lot of stuff with the Cassie allegations, even when her friend came out, a lot of that stuff was just kind of corroboration. It wasn't anything new. And so I didn't like jump on to just kind of talk about it, because it was like, and that's how I think at this point with Roger Bond, her lawsuit was filed, what, 3 weeks ago or something. So it's kind of like, what you have to say, I ain't even that interested anymore. But I think his main purpose is he's trying to get help for his son, which is understandable. It's honorable. That's what you're supposed to do as a parent. But I think the way he went about doing it just looks faulty to me. Like, it's like, what? You was like, oh, this is my only interview. Now I can get back to my son, and y'all quit asking me about what I know as pertains to Diddy. Then to come in within the hour, I'm charging $25,000 for every interview because it'll help. That's what I need for my son. So it just goes back to me thinking a lot of this was, you thought perhaps maybe Diddy was gonna come in and give you a couple of dollars or something. It just really made it sound like he was using it to capitalize. So he doesn't know what he wants to do, but I understand this. Yeah, so I said it's a catch 22, but I think he could have been a little bit more methodical about it. He was just obvious to me. I was like, so he's posting this stuff about, I know this, I know that, I'm gonna speak my truth, I'm coming out, and then an hour later you got your son's information, and then you'll delete the other stuff, and then it just has your son's, but you got all these new. Then he was like, oh, I did this because I figured I want to know how many people I can get to follow me based off of this. And it was just too much with him. So, and Gloria Velez, we talked about her, Aaron Hall's baby mother. She's posting a lot too. She's posting a lot of her, like, posting a lot of like her pictures and all of that. So said no one can explain why Kelsey said he shot over the front door from the back seat, but Meg said he shot from the back seat. They are both liars, and Tory did not shoot that three. All right, Mr. Nephew, I got you. Renaissance. Well, we'll see what the court say. Renaissance woman said, I think the bodyguard is there to purposely cause confusion. I'll just say I'm glad that they came up with something else, and they actually got somebody who seems like they are, can somewhat validate what they've been saying. So I'll give them that. And I think if this was evidence that was presented, it probably would have swayed his case a little bit. Where at least we have some like I could see why people are screaming the way they are, but if it's true, I don't know. It seems a little shaky to me just because of all the reasons I've already said. But anyway, y'all, it's 12:30. Thank you guys for rocking with your girl. I'm about to go to bed and I hope you guys do the same. It's 12:30 over here on the East Coast, so I know it's still early on the West Coast, but I gotta go. Thank you guys so much for tuning in this late. Thank you for all your support. If you have not hit that like button, make sure you do that for your girl. Make sure you subscribe if you have not done so already. We are at 21,000, and it's all because of you guys and all of your support. Thank you again for everybody that has super chatted, asked questions, engaged, and all of that. We'll be back to do it again, hopefully sometime this week. Until then, you guys have a good night.